You may have come across the headlines or heard the growing buzz. The UK's traditional 5-year pathway to indefinite leave to remain, commonly known as ILR, could soon be extended to 10 years. For thousands, this represents a major shift that could fundamentally impact long-term plans and future stability. So, what exactly is changing? Who stands to be affected? And perhaps most critically, will these proposed changes apply to individuals who are already in the UK under the current 5-year visa system? In today's video, we'll unpack the latest developments regarding the government's proposed 10-year ILR and settlement policy. Using official government publications and insights from immigration experts, we'll separate the confirmed facts from the speculation and give you a clear view of what lies ahead. Let's begin with the origins of this proposal. In May 2025, the UK government released a white paper titled Restoring Control Over the Immigration System. This policy document outlined a broad range of measures aimed at addressing what the government described as unsustainable levels of net migration. At the center of this proposed overhaul is a newly introduced concept, the earned settlement model. Here's the key proposal under this model. The minimum qualifying period for most migrants seeking permanent residency through work or long-stay visas would increase from 5 years to 10. According to the government, settling in the UK should no longer be seen as an automatic outcome of spending 5 years here. Instead, they argue it should reflect a meaningful, long-term contribution to British society and the economy. This proposed 10-year rule is expected to apply to a wide range of work-based immigration routes, including the widely used skilled worker visa. Naturally, the biggest question now is, will this change apply to everyone? While the white paper outlines the 10-year standard as a new default, it also clarifies that the rule may not apply universally. There is still a great deal of ambiguity around who exactly will be affected. However, the clearest indication is that the main work-related visa categories, such as the skilled worker route, are the primary focus of this reform. In addition, the government has alluded to possible inclusion of other long-term visa categories like global business mobility and skill-up routes. Those specific details remain under review. And now to the question most applicants are urgently asking: will these changes be applied retrospectively to those already on their 5-year ILR journey? And every written part based on your input. Let me know if you'd like the next part continued. So, will the new 10-year settlement policy be applied to those already on the path to permanent residency? The truth is, at this stage, we don't have a definitive answer. The government's white paper stops short of confirming whether the proposed changes will be applied retrospectively, and that uncertainty has sparked major public concern. In fact, more than 145,000 individuals have signed a petition urging the government to exempt current visa holders from the new rules. The Home Office has pledged to launch a formal public consultation later in 2025, during which this issue of transitional arrangements is expected to be front and center. Until then, many individuals remain in limbo. However, there is some clarity and relief for certain groups. The government has already confirmed that several visa routes will remain unaffected by the proposed 10-year extension. Most notably, the current 5-year path to settlement will continue for immediate family members of British citizens. This means that spouses, partners, and children of British nationals can still expect to reach indefinite leave to remain within 5 years. In addition, those granted refugee status or humanitarian protection will continue to benefit from accelerated pathways to settlement. Safeguards for vulnerable individuals, such as survivors of domestic abuse, will also remain in place, allowing them to apply for ILR under existing special provisions without being subject to the 10-year rule. But here's where the government's new earned settlement model adds another layer of complexity. The proposal doesn't simply replace the 5-year rule with a flat 10-year requirement. Instead, it introduces a new points-based system that could allow certain individuals to shorten their route to settlement. Although full details have not yet been released, the white paper hints that applicants may earn points for contributing to key sectors with labor shortages, for community involvement, or for demonstrating advanced English language skills. In theory, this could allow someone working in a priority industry to qualify for settlement in 7 or 8 years rather than waiting. The full 10, but for now, that remains speculative. We'll need to wait for the government's formal consultation to understand how the system will actually work. Now, let's address a point of confusion we've seen circulating widely: the difference between the proposed 10-year settlement route and the existing 10-year long residence route. It's crucial to understand that these are two separate tracks. The long residence route has been part of the UK immigration framework for many years. It allows individuals who have lawfully and continuously lived in the UK for a full decade regardless of visa type to apply for ILR. It's often used by those who have switched between multiple visas over time. That said, even the long residence route has undergone significant changes. As of April 2024, key eligibility criteria were updated. One major change was the removal of the previous 548-day absence limit over 10 years. Under the new rules, applicants must not have spent more than 180 days outside the UK in any rolling 12-month period throughout their qualifying time. Another critical update involves a minimum visa duration requirement. If your current visa was granted on or after April 11, 2024, you must have held that specific visa for at least 12 months before applying for ILR via the long residence route. This effectively means that even if someone reaches their 10-year anniversary, they may have to wait longer before they become eligible. Finally, another important revision is the discontinuation of so-called historic applications and practical terms. This means you must meet all current eligibility criteria under the updated framework, regardless of when your original leave to remain was granted. Until recently, individuals could sometimes rely on a past decade of lawful residence to qualify for settlement in the UK. That option, however, has now been removed. To clarify, the government is proposing an entirely new default 10-year settlement route for many visa categories. This is separate from the existing 10-year long residence path, which has itself undergone key changes. This extended timeline to settlement isn't being introduced in isolation. It's part of a broader and much stricter set of immigration reforms outlined in the government's recent white paper, each aimed at tightening entry and settlement criteria across the board. Let's break down some of the most significant changes. First, there are major adjustments coming to the skilled worker visa route. The minimum skill level required is set to be raised from RQF Level 3 equivalent to a levels back up to RQF Level 6, which corresponds to a university degree. Alongside this, salary thresholds are expected to rise considerably, placing additional pressure on employers and applicants alike. Then, there's the closure of the social care visa route. Beginning in 2025, new applications for overseas care workers and senior care workers will no longer be accepted under the Health and Care Worker Visa Scheme. Also under review is the graduate route, which currently allows international students to stay and work in the UK after completing their studies. Proposed changes could include shortening the duration or requiring a confirmed job offer for eligibility. Another key update is the increase in English language requirements. For most work and family-based visa routes, applicants will need to demonstrate proficiency at the B2 level in order to qualify for settlement, raising the bar significantly. When you look at all of these reforms together, higher skill thresholds, stricter salary requirements, a longer path to ILR, and tougher language standards, a clear pattern emerges. The government is moving toward a more selective, skills-based, and tightly controlled immigration system. So, what happens next? It's essential to understand that these proposals are not yet in effect. A white paper is a statement of intention, not a piece of legislation. None of these changes are law at this stage. The next major milestone is the public consultation, which the government has announced will take place later in 2025. That will be the key opportunity for individuals, businesses, advocacy groups, and immigration professionals to provide feedback and potentially influence how the final policies are shaped. That consultation will also be the moment we may finally get clarity on the biggest unanswered question: will these changes apply To people already on the 5-year path to ILR, so far, over 145,000 people have signed a petition urging the government to protect current visa holders from retrospective changes. A formal government response to that petition is expected and could offer crucial insight into what lies ahead. In the meantime, the best course of action is to stay informed. Make sure you're following updates from official government sources such as the gov.uk website, and consider speaking to a regulated immigration advisor you're unsure how your personal situation may be affected. To recap, the UK government is proposing to make a 10-year route to settlement the new standard for many work visa holders. Certain groups, such as family members of British citizens and refugees, will remain exempt from this change. A possible points-based system may allow some applicants to reduce their qualifying period, but no official framework for this has been announced. The crucial question of whether current visa holders will be impacted remains unresolved. We are in the midst of a significant period of policy change and uncertainty. We'll continue to monitor the situation closely and will bring you timely updates as more information becomes available. Now, we'd love to hear from you. What are your main concerns about these proposed changes? What questions do you believe the government needs to address in the upcoming consultation? Share your thoughts in the comments below. If you found this video helpful, don't forget to give it a thumbs up, subscribe to the channel, and turn on notifications so you never miss a future update on this critical topic. Thank you for watching.